SJC-12784, Department of Revenue, Child Support Enforcement, v. Joshua Grullon.
Ms. Richardson, good morning.
Good morning. May it please the court, my name is Anna Richardson. I'm here from Veterans Legal Services on behalf of the appellant Joshua Grullon. I want to recognize our senior staff attorney Eve Elliott, who is second chairing the case today, as well as our co-counsel from Skadden, Catherine Fisher, and Caroline Trusty on the briefs. The case before you today concerns the critical issue of what process an indigent person is due before we use the power of the court and the Commonwealth to deprive them of their physical liberty in a civil contempt action. As Mr. Grullon's case illustrates, the appointment of counsel for an indigent defendant is essential to prevent wrongful incarceration of persons both too poor to comply with the court's orders and unable to advocate for themselves adequately. This case makes clear that substitute procedural safeguards are not enough to protect an indigent defendant whose freedom is at stake.
Is that in every DOR, whenever DOR brings a contempt action, do they always request the alternative of jail time?
You would have to ask the department as to their traditional procedures with regard to jail time. In each contempt, incarceration is a theoretical possibility.
Right, that's what I'm trying to understand. So is it an all or nothing proposition? Could we say that you get counsel if DOR is requesting the option of incarceration? Say it's the first step in the process. They're coming in, they're holding them in contempt, but they're not seeking jail time. Do we need a lawyer in that case?
If jail time's not being sought, the only circumstance in that case where potentially a lawyer might be required is if at some point in the proceeding the judge begins to think sua sponte that they think incarceration might be appropriate.
Yeah, there's a practical consideration here because is a CPCS supposed to set up a bullpen? So I mean, in this case, in many ways, your client talked himself into contempt, right? So it was going okay until he said something he shouldn't have said, and recognized that, and the judge says, now you're going to jail. We can get into whether that should have happened or not, and what showing should have happened. I'm sure you'll discuss that. But practically speaking, as Justice Kafka's alluding to, the judge should basically, in your world, stop the hearing and say, I'm thinking about sending you to jail. Now we're going to appoint counsel?
That's correct. So we're not seeking that counsel be appointed in all contempt matters. As this court has distinguished in cases like Patton, there is a difference between when incarceration is a theoretical possibility versus when it's a palpable potential result of the proceeding. So what we're asking this court to do is to hold that a defendant may not be sentenced to jail in a civil contempt matter unless counsel is appointed at a meaningful time and in a meaningful manner. I'm just trying to understand how that's going to work in the real world. But because there's always a sort of a possibility that things are going to get messy. So you're not saying that a counsel needs to be appointed whenever DOR brings a contempt action, right? Correct.
Okay. But I'm trying to understand what's the theory. How do we define this theoretical possibility? Is it a request for incarceration, or is it as soon as the judge decides, like this judge, he's aggravated and he's thinking of putting you in jail, then you stop the proceedings and call for counsel? I'm just trying to understand practically, because we've got to give some guidance out there, because there are, I guess, 60,000 of these, or there's a huge number of them going on.
So what we're suggesting here is that when the other party is requesting incarceration, the trial court judge would need to determine if that is reasonably a remedy that it wants to retain the discretion to order in that case.
When the other party, I take it when the other party is DOR, not when the other party is a pro se. If we have two pro ses, aren't we running into this asymmetry the U.S. Supreme Court talked about? Is it only when DOR requests it, or is it whenever anyone requests incarceration?
It's when the court determines that it wants to retain the discretion to order incarceration as a remedy. So a pro se party could come in and say, I want incarceration, even though the father has shown up and paid 90% of the arrearage that day, and the judge may know immediately that's not something they want to entertain. Conversely, there could be instances, they're rare, where the party's not requesting it, DOR is not requesting it, but the judge does determine through the course of the proceeding at some point they're contemplating ordering it.
Is that only going to happen when there's a determination by the judge that the person that's before the judge has the ability to pay but chooses not to?
Yes, ability to pay is the critical inquiry.
Yeah, it's an inquiry, though, that can be made ahead of time, which is what the DOR is suggesting, as I understand it in their brief.
Yes, and I would submit that if the department is doing its due diligence in inquiring into ability to pay before bringing these contempt actions as are required by DOR's own procedures and the federal regulations, the instance in which you have an indigent defendant that the Commonwealth would have to pay for counsel for that also is found to have the ability to pay is going to be relatively rare, because by definition, DOR should rarely be bringing a contempt in those instances when that person's income is so limited to begin with.
Would that be the only issue really that's at play? I mean, there are not other issues at play in terms of a contempt that an indigent person would be facing. Contempt for having violated what other kinds of orders are there, other than payment orders?
Certainly, and what we're arguing for is that the issue here is that we are depriving a person of their physical liberty. We are by definition taking something away from them that we have no capacity to give back. So we need to be certain in those instances.
It's a way of saying you have the ability to do this, you're choosing not to, you're in defiance of the court, right?
Yes, and in the case where the defendant truly holds the keys to their own release and is able to comply, then these additional procedural safeguards are not necessarily warranted. But as here, where you have a defendant who would not have been allowed to make the comments to the court that he did if he had had counsel present, he would have had someone to effectively advocate for him. He would not have been incarcerated on this record had he had counsel, because the case would have been presented radically differently.
That's what makes me nervous, because that case, no one was considering incarceration. Well, I guess DOR had requested incarceration in his case, right, as a possibility.
That's correct.
Okay, so there he should have been appointed counsel in your view because they've requested it?
Or the judge should have indicated on the record, I'm not appointing counsel because I am not entertaining that remedy at this time. So, again, we're not proposing every single contempt action, but that where the court is going to order incarceration, that can only happen if the defendant's been appointed counsel at a meaningful time and in a meaningful manner.
But you're saying it wouldn't be meaningful here because he had already started to talk and get himself into trouble.
That happened after DOR had requested incarceration. So at the very outset of the hearing, when that request was made, the judge would need to determine if he was entertaining that remedy.
That's the only time it would be meaningful.
Yeah, if I can step back, put aside the issue of counsel for a moment. Let's just focus purely on what is required under Turner. The world, as it should be under Turner, and for that matter under Burchell, would be that when there is the possibility of somebody being held in civil contempt and being placed in custody as a result, there would need to be notice given to the defendant that ability to pay matters a great deal, and there would need to be an inquiry into ability to pay, correct?
Correct.
Do we have any, by the way, reason to believe that that, in fact, is happening in the DOR session of our probate and family court?
As DOR noted in their brief, they send a stuffer, I believe, with the complaints. They can speak better to their own procedures than I can.
What's a stuffer?
A piece of paper that is sent out with the complaints. It's, again, they can speak better to their own procedures than I can.
Is that supplement number 7? Important notice regarding contempt?
I believe so, yes.
That's a
Ability
stuffer?
to pay child support is critical issue in determining whether or not you will be found in contempt. That's the record, it's page 7, right?
That's my understanding. I have I don't know if Mr. Grullon was served at in this case. It's certainly not something that's delivered with the summons or the court complaint, which he was served with by the sheriff. I would also note another requirement of Turner is express findings as ability to pay. And
Which would require there to be some hearing or some evidentiary.
yes, and the Birchall standard articulates it must be by clear and convincing evidence. If I can draw the court's attention to the order in the Jimenez matter on addendum page 9192, you can see that as recently as July of 2017, the form order in these cases did not include an express finding as to ability to pay, which causes, and that form order was in place in some of the other cases that we also referenced in our brief from the lower court, where we had indigent veterans who were incarcerated without counsel and without those findings being made.
So going back to Justice Kafker's earlier question in terms of the practical consequences, today, where there is no right to counsel, and there is a DOR request to say, I wish this particular person to be held in civil contempt and that the person be jailed for failure to pay, does the judge then give the defendant the opportunity to sort of establish the inability to pay? I mean, there would need to be some hearing on that. Is there some, is there a continuance given in order for that to occur, or do they just ask the person right then and there, tell me about your ability to pay?
Well, the burden is on the defendant to show at least some type of prima facie evidence of inability to comply because the prior order was put in place, presumably as a well-founded order. But I would submit that, as the record reflects here, it's important the counsel be appointed before a defendant potentially prejudices themselves as to the final outcome of the matter. There are 33 states that recognize some form of right to counsel in civil contempts in family court, and each of them has taken varying approaches to this. So, for example, in New Jersey, in the matter of Pasqua v. Counsel, the court found a right to counsel and then referred the matter to a committee for to determine how best to develop rules for implementation of that right. In Connecticut and Texas, the courts have held that counsel is indicated when the court determines that incarceration may be appropriate as a remedy. In Ohio, defendants must apply for public defender services if they believe they need them when they receive the contempt summons. And in other contexts, such as Maryland, where incarceration may result, counsel is required. So there's a range of options that this court could look to in terms of the implementation of a right, but I would submit that that's a distinct inquiry from whether the right itself exists.
But pragmatically, going to the question Justice Gaziano and Justice Kafker asked, it would mean that you'd have to say, I will appoint counsel in your world, I will appoint counsel for you, Mr. Grullon, and we will have it heard on a new DOR day.
That's correct, and I think this case illustrates how helpful that cooling off period could be in terms of the environment of the probate and family court can be quite frustrating. DOR day can be quite hectic. Had that happened and had everyone had to have come back, and it can be very short return date. It's not something that requires months and months of delay. But if everyone had had to come back with Mr. Grullon having counsel to explain his comments to the court, I don't believe that he would have been incarcerated.
Ms. Richardson, can you tell me why, with your analysis, an individual wouldn't be entitled to counsel in the district court in the supplementary process session when there's been a judgment that has entered and there's a determination of whether or not somebody has the ability to pay, and if they don't, that they face incarceration? What's the analysis as to why that individual in the district court supplementary process session wouldn't be entitled to counsel?
Well, I'm not sure that they wouldn't be. Our critical inquiry here, again, is the deprivation of that liberty interest. And we believe that under the Massachusetts Constitution, where that fundamental right is at stake, counsel should be appointed. That is not the case before you today. There could certainly be nuances to the supplementary process session that I'm not aware of where other substitute procedural safeguards could be adequate. Apart from that, we have the federal Constitution and Turner also setting a floor, not a ceiling on these cases, and where opposite counsel, as we have in this case, I think that shifts the analysis under the federal standard as well.
Just to be clear, we're dealing here with a DOR attorney who was seeking it. Are you saying that we should extend this right to a situation where DOR is not involved and there is simply one spouse who is herself, usually herself, unrepresented, asking for contempt for the husband?
If the other spouse is asking for jail time and the court is seriously considering ordering jail time, then yes, we would. It's again, the deprivation of that person's freedom by the state that we believe triggers the right in these instances.
But isn't almost every one of these contempt actions that somebody's seeking, all the pro bono ones, they're often seeking jail time, aren't they? I'm just trying to understand, again, the limits of this.
I'm not sure that I follow as to the pro bono component.
Self-represented.
The jail time should only be sought when the defendant has the ability to comply with the order and is willfully choosing to do so. So someone who there is evidence that this person has income or assets that they are not applying to fulfill this obligation,
Once DOR is involved, and we're assuming a certain level of professional investigation, when they're requesting jail time, you've got a lawyer and a request for jail time. When we've got self-represented on both sides, obviously they think that you can pay and they're angry. Are we really, every time a self-represented person seeks jail time, you have to appoint it, or is the judge going to make a determination in the hearing?
I would submit the judge is making a determination in that hearing as to whether they feel jail time is something they want to retain the discretion to impose. And most often, the court has some idea throughout the course of the proceedings that's something I'm considering or not, and that could be based on prior history in the probate and family court. Is there a lengthy history of this person having assets and not using them to fulfill this obligation? Is there evidence on the financial statements that there is ability to pay? Has that due diligence been conducted prior to the hearing? If DOR is involved, that there is evidence that this person has resources and again is willfully choosing not to use them for this purpose.
Or willfully chooses not to work.
What's that?
Willfully chooses not to work.
Well, and you are correct. The court can impute or attribute income in certain circumstances. That can be quite a complicated inquiry into someone's earning capacity, and one where counsel may be necessary to assist the person in presenting why it is that they're not able to work. I know in our context with veterans, the average wait time on VA benefits appeals is 5 years. So we may have a disabled individual who is trying to access a benefit, not able to do so, and simultaneously unable to work, and has a great deal of difficulty presenting that evidence to the court.
All right, thank you.
Thank you.
Mr. Kravitz.
Thank you, Mr. Chief Justice, and may it please the court. As the Supreme Court held in Turner versus Rogers, the fundamental and critical question in this case, in cases of this kind, is whether there has been a fundamentally fair determination of the key due process question, that is the ability to pay in cases like this. And on the record that we have in front of us in this case, it appears to us that for 3 different sets of reasons that we cannot be confident that that occurred in this case. And therefore, unfortunately, I agree with my colleagues that the contempt judgment in this case should be vacated. So, and as I said, there are 3 sets of reasons why we think that's so. The first has to do with the safeguards that are laid out in Turner. As you referenced earlier, there are 4 safeguards. We are not confident about 2 of them in this case. There is the requirement, as was referenced earlier, that clear notice must be given that the ability to pay is the essential issue in the case. And it is not apparent from the record whether Mr. Grullon was so advised when the complaint was served or at another time.
So we're not.
Yes.
So this the supplementary appendix number 7, that we're not sure whether that was sent to him.
We cannot tell from the record. That's correct. But that is the paper that that we're referring to.
Yeah.
And then the second issue, perhaps a more important one even, is that Turner also references express findings by the trial court that there is an ability to pay the order. And under Birchall, of course, it must be by clear and convincing evidence in Massachusetts. And again, from the record that we have, there is a form in the record appendix at page 31. It's a little bit difficult to tell whether the box that indicates that an ability to pay finding was made has been checked. And there's nothing in the transcript of the hearing that indicates findings made on the record that there was an ability to pay, certainly not that there was an ability to pay the specific purge amount of $500. So that's the first set of issues. The second set of issues here is that, as was referenced earlier, federal regulations and DOR's own policy require that these cases should be screened by DOR staff before DOR determines to participate, to serve the complaint, to appear, and then to advocate for contempt and for perhaps particular conditions of contempt. Again, it is not apparent from the record that that occurred in this case, and so that's a second set of issues. And then the third...
I'm confused. How could they have been hired if they hadn't screened it? How could they appear in court if they hadn't screened it?
My understanding of the way this works, and I'm sort of outside the record a little bit here, is that this complaint was filed directly at the court. It was not filed with, it was not sent to DOR, which is another way you can do it. It was filed with the court. It somehow, something happened. It sort of bypassed the screening process and went directly to the office that serves the complaints. And then the case was scheduled for the DOR session. And so then the DOR attorney was present and had the information that is reflected in the record. So that's sort of what we know as to what happened. And so again, that's why we're not confident that DOR's proper role was exercised here. And then the third issue is, as was mentioned earlier, the probate judge in this case appears to have allowed her perception of the, quote, poor attitude, unquote, of Mr. Grullon to have influenced her decision to incarcerate. We agree that that was error. And so sort of for those...
That doesn't happen too frequently, but DOR is a very stressful day. And it seems like this was more, punishment for a comment that he made about the mother's ability to function okay, she'll be okay, or whatever the comment might be. Isn't this case the quintessential example of why, in at least limited circumstances, that counsel should be available?
Well, so to speak to that broader issue, we don't think it's necessary to have a blanket rule in these cases, and of course this is laid out in the brief, but we don't think it's necessary that there's a blanket rule that in all of these cases or in some sort of globally defined subset of these cases that counsel be present. We agree, there were multiple errors that occurred in this case. Perhaps the presence of counsel might have prevented them, but we hope and expect that this is a rare case, this sort of a perfect storm of factors that happened here. And as Matthews v. Eldridge itself makes clear, due process rules of this sort are supposed to come from the generality of cases, not from the particular rare exception where essentially everything goes wrong.
Could you tell me what it was that should have happened here that didn't happen here? What should have happened? Once this is underway, what should have happened?
Once the hearing was underway?
What should have happened?
So, well, what should have happened is there should have been an inquiry at the hearing into Mr. Grullon's ability to pay either the full amount or some modification of child support.
Right, and how could he do that? How could he do that without counsel?
Well, so the question, as this court has considered the issue of defendant's ability to pay on multiple occasions in a slightly different context, which is the determination of indigency. But as the Supreme Court has recognized in Turner versus Rogers, that is a closely related inquiry to the question here. It's ability to pay for counsel versus ability to pay child support. But in both situations, all of the information that goes into that, at least on the input side, is in the control of the defendant. The defendant knows what his income is, what his assets are, what his expenses are, and so forth. And there's a form, a standard sort of income and asset and expense form that is in Volume 2 of the appendix
Has
here.
the judge already determined that he is indigent?
There was no determination either way in this case of indigency, because there was no request for indigency and there was no request for counsel prior to the hearing in this case.
Well, there's
So
no-
that-
there was no-
Doesn't that kind of sort of prove the point that counsel would be very beneficial for the father?
Well, I guess I don't see that follows. I would add, first of all, that the answer to the complaint for contempt and the counterclaim for modification, those were prepared with the assistance of counsel, and there was no request for a determination of indigency or request for counsel made at that time. That was all prior to the hearing. And so, this goes to the general, as we've stated in the brief, we are sort of uncertain whether this broad question of right to counsel ought to be addressed in this case. It's not clear that it was properly presented.
But if DOR is pushing for incarceration, I'm giving those two examples that your sister just, DOR is pushing for incarceration. You have an able lawyer representing DOR, or the judge on her own is starting to think, I'm going to put him in jail. You don't think counsel in those two subsets is required?
Not as a global matter in these kinds of cases. And the reason for that simply goes back to the three Matthews v. Eldridge factors. And so let me turn to that, if I may. So the first factor, of course, is the private interest at stake, avoiding improper incarceration. Absolutely no dispute that is an extremely important interest. But that's not the end of the inquiry. That is one factor.
Got two parts more. Go ahead.
Correct. The second part is the risk of erroneous deprivation, and given the existing safeguards and the relative value of including additional safeguards against improper incarceration, right? And then the third is the governmental interest.
Okay, so in the second part of this, okay, DOR is determined to put the person in jail and believes the person has the assets. You believe that because it's a financial inquiry, we don't, to me, then I'm just wondering if that's always the case, then, that there's never a lawyer. Because is it your position then that this can be done without a lawyer because it's just how much money do I have?
As the Supreme Court has recognized, as the Appeals Court has recognized, in most cases, not in every case, but in most cases, the ability to pay inquiry is likely not to be a complex one.
An example of a case that's the exception.
Of the complicated case?
Yeah.
So I think a possible counterexample is the Porter decision from this court. That was an indigency in terms of whether it was a criminal case. So it was appointment to counsel in that context. Right. But the facts there were not straightforward. And there were, I think, 3 properties owned by the defendant, and there were tax liens and mortgages and possible attribution of spousal assets and so forth. That was certainly a much more complicated set of facts than this case. But even so, I would say, in that case, the determination of indigency, namely whether she was entitled to a lawyer at her trial, proceeded pro se. And this court, I'm not sure the issue was raised, but the court did not perceive any difficulty with having it pro se, and the court also concluded that at the end of the day, it was appropriate to place the burden of proving indigency on the defendant in that case, again, for the same reason, that however complex the facts may be, it was the defendant who was in control of them, who had the best access to them. So if I could just say a couple of words more about the governmental interest on the sort of the third prong of the Matthews inquiry in this case. The interests are not only that, of course, the Commonwealth has an interest in avoiding unnecessary administrative and financial burden of locating and compensating appointed counsel. But the entire purpose of this federal-state construct for child support enforcement is to ensure that parents who are entitled, because the custodial parent who is entitled by court order to child support gets it in a reasonably timely fashion so that she in most cases, not every case, but so that the custodial parent can look after the child and can adequately feed and clothe and house the child. So that is the governmental interest in this case. It is an important one. And so to return to the discussion that occurred earlier about sort of the practicalities of how this would work, I would agree that if this goes the way it's been proposed, so that there's some sort of determination in the hearing, the judge concludes that incarceration is perhaps appropriate, at that point, presumably the hearing would have to stop. There would be a determination as to whether the defendant is indigent, and if he is, then counsel would be located, counsel would be appointed, and presumably given time to confer and to learn the case so that the representation can be effective.
So
You are building delay into this process.
Along those lines,
Yeah.
can you tell me whether you think under the public burden this is or isn't a legitimate concern? Because there's no record behind what I'm going to suggest. If the mother is in court seeking to have the child support paid, and the case is continued to another day, I expect many times what that means is, in addition to coming back another day, it's another day of the mother missing work and losing money. Is that a fair consideration under Matthews as to the public interest issue?
Just in terms of having to come back to another...
Well, the burden on the custodial parent of making another appearance in court, including the financial burden involved.
Sure.
When they're in there trying to get enough money to pay for their kid.
Sure, absolutely. I would say there are a number of costs to the custodial parent that the delay in rescheduling would impose. This would be one of them. Certainly, and in addition, just the fact of delay means that you have an additional number of days or weeks in which presumably the custodial parent is not receiving the child support payments that they are entitled to. So all of these things weigh in the government's interest. So then what really drives this, I think, is the risk of erroneous deprivation factor, where, and that is what really distinguishes a case like this from cases like JKB, where the court has found that there is a right to counsel in certain civil proceedings, family law proceedings. And the court emphasized in JKB that when you're talking about termination of parental rights, it's a trial. There's evidence, there are witnesses that have to be examined and cross-examined. There may be, as the court said, sophisticated expert testimony, so experts have to be located, prepared, examined, cross-examined, and so forth. This is what lawyers are trained to do, and that is the proceeding that was at stake in JKB, and then its progeny have held similarly. This case, again, the inquiry here, in most cases, is not likely to be that complicated. It's like to be reasonably straightforward.
Well,
There's nothing in this record, for example, that suggests that the inquiry is complex here.
So if it's all so simple, why does DOR have to be involved then? I mean, you know, if the mother can just walk in and do this, and the judge can sort this out, you're bringing the power of DOR to the equation. That seemed to be the issue for the Supreme Court as well. So this is also simple. What's DOR need to have a lawyer there for?
So, I mean, DOR, under both federal and state law, has the obligation to offer assistance, which includes enforcement of child support.
Right. No,
so it is directed by...
No, I get why they're there, but
yeah.
they're there because it's not quite so simple, right?
Let me answer it this way.
And can I ask another question?
Yeah.
DOR can garnish wages, right?
Correct.
So DOR has, in the simple case where somebody's got a job, they can just go directly and garnish the wages, right?
I believe that's right. There is a wide range of remedies that DOR has available to it.
So I'm just trying to understand, is what we're dealing with the more complicated case? where DOR thinks they have money, but they can't just simply, put a, again, this is an old memory, but I thought DOR can just garnish someone's wages.
I believe that's correct. I don't, off the top of my head, know the exact procedure that's involved in that. But yes, as I said, DOR has a wide range of remedies, and no one, DOR included, is interested in just sort of incarcerating people because they can't pay. Right. This is used, it should be seen as a last resort when its other options have failed, but it believes there is a need to coerce compliance, and if the system is working as it's supposed to, that should be the limit of how this remedy is used.
So how much notice did the defendant here give that there was to be a request for him to be held in contempt and to be held in custody?
If memory serves, the complaint was served on him in October, I think October 19th, something like that. I can pull up the exact.
The complaint for civil contempt?
The complaint for contempt.
Okay, and was it made known that he would?
Excuse me. The complaint was served on September 17th. It was served on him September 17th, according to the document. This is page 15 in the appendix.
And the hearing was?
And the hearing was November 1st, so roughly 6 weeks. And again, there should have been included with the summons the stuffer that was mentioned earlier.
So you're here on behalf of DOR. Can you tell me how often there is truly an evidentiary hearing or a true opportunity to examine ability to pay at a DOR hearing?
As the public records request that was submitted as part of the supplemental appendix indicates, there are a lot of hearings in these cases. Over about 2.5 years, something north of 12,000 hearings occurred.
And my question is how often? I mean, I know that the record reflects a number of cases involving a number of probate and family court judges who have ordered contempt with custody without a finding of ability to pay.
You're referring to the cases in the footnote in my colleague's brief.
Right. The question I'm asking you is, based on your client's involvement in DOR hearings, how often are there true evidentiary examinations of ability to pay?
I cannot give you a percentage.
Isn't that just can you give me any information as to whether this is, you have characterized this as an outlier. Do you have any basis to characterize this as an outlier as opposed to something within the realm of the norm?
I have no reason to think that in general, DOR is not following its procedures. But I can ask for further information from the agency.
I'm referring to whether the probate and family court is following its procedures as well. I mean, here basically, this is a perfect case for them to bring as a test case. So DOR fell down, probate and family court fell down. This is a complete failure to abide with obligations under both the Massachusetts and United States Constitution to examine the ability to pay. And they're basically saying that the remedy that we should impose for that is to appoint an attorney to ensure that those obligations are followed. Can you give me any information to indicate whether or not this is an outlier or whether this is within the norm?
I certainly don't think it's within the norm, Your Honor, but I cannot give
Based
you
on what?
I cannot give you information off the top of my head. I can submit a letter after argument if that would be helpful to the court.
Isn't that sort of what this case is about?
I think what this case is about is what are the requirements of due process in these kinds of hearings.
But the requirements of due process are in part based on the extent to which an attorney is needed to ensure that a fair hearing is being conducted, and the extent to which a fair hearing is routinely being conducted and all the protections that you identify are required constitutionally are being in fact furnished would matter in terms of our evaluation as to whether or not we have a systemic problem or not.
In terms of information that I could helpfully supply to the court, again, I will consult with my colleagues at the agency.
Can I ask,
and I can get back to
maybe
you.
throw you a little lifeline here? I'm not sure. The financial statement is often required in these cases, right? The probate and family court has a financial statement.
That's correct.
So is that mandatorily attached to the civil contempt summons or any of the other documents? Do we know sort of practices in this area?
It is supposed to be included with the summons. The financial statement, the information about what is going to be at issue at the hearing is all supposed to be included with the summons. You know, again, we don't have in the record.
So there's some, you may have some ability to determine just by how often that occurs, whether this is an outlier or not. I mean, because it looks like financial information as a matter of course is required.
It is. It is absolutely correct. Yes, I mean, that statement is supposed to be present in every case.
It may not be quite the danger the chief is worried about, but.
One certainly hopes not, Your Honor.
Can I just satisfy my curiosity? What is a stuffer?
It's just a piece of paper that, it's exactly the piece of paper that is at, I think, page 7.
Is it like an insert?
Page 7 of the,
Another word for insert?
it's an insert, yes, exactly. I don't know why
But
this
you
one is
both
called a
obviously
stuffer, but it's a
both-
piece of paper that is included in the envelope along with the complaint for contempt.
Okay, but there's no reason to think it was included in this case. Is that what you're saying?
We cannot tell from the record whether it was. It is standard practice. It is DOR's standard practice that piece of paper, along with the financial statement, is included in with the complaint if DOR chooses to serve the complaint. But again, it is not apparent either way from the record whether it was included in this case.
Now, the brief makes clear that DOR is not acting as the attorney
Correct.
in this case, but it is a party seeking civil contempt. So how is its role defined?
So you're absolutely correct that DOR does not represent either parent in these cases, and it does not have any sort of attorney-client obligation to either parent. And so, again, the way it is supposed to work is that DOR is sort of a broker of information. If it has done the investigation that's set out in its procedures, it will presumably have information about various potential sources of ability to pay, and its obligation is to present that information to the court in order to help the court make a determination one way or the other about whether there is ability to pay in this case.
Isn't that a little understating DOR's role? The woman in this case doesn't even show up, right?
She is present at the first hearing.
Not the second hearing. DOR is the sole person pursuing her interests, right? It's not really acting as a neutral here.
So let me sort of clarify the sequence of the hearings, if I could. So at the first hearing, the mother is present, but absolutely, DOR is present at that hearing and does advocate both for contempt and for incarceration, as we have agreed, that was error and under the circumstances. At the subsequent hearings, I believe, the second hearing, there's confusion about whether the counterclaim was filed and so forth. But the third hearing, the mother is not present. DOR is present, but there has been, I do think it's important to address this, the characterization of DOR as advocating against the modification in that hearing. It's a short hearing. I've read the transcript multiple times. I honestly don't see it. It seems to me what DOR does in that case at that hearing is that they agree that that Mr. Grullon's income has gone down from the previous month to the present month, and that might affect the bottom line. And then at the end of the hearing, the judge enters a very substantial modification, and there's no objection from DOR. So it does not, I just don't think it's an accurate characterization of DOR's role at that hearing, that it was advocating against the modification. If anything, it was agreeing that the circumstances had changed.
Chief, can I ask one last question? So say we disagree with you and believe that a lawyer is required if a judge is going to considering putting the non-responding spouse into jail. the Commonwealth's interest, the Commonwealth's going to have to pay for this lawyer, right?
Correct.
Have you done any thinking on sort of how much that would cost and how, because I take it in the second calculus, or the third calculus, the Commonwealth's interest, we would have to consider the cost of the Commonwealth of imposing such a burden, right?
That is certainly part of the government's interest in this case. of course.
And what, do you have any sense of what that could amount to?
I mean, I don't, because it depends on the parameters of the right. You know, I think there is some disagreement between my colleagues and between some of the amici as to what the triggering event ought to be. My colleague argues that even if it's pro se against pro se, as soon as the judge is considering incarceration, then the right to counsel ought to attach.
We know the number of people who've been incarcerated? I've read some of the briefs, but I've not read all the amicus briefs. Do we know the number who've been incarcerated?
I do not think we have a global number for that. What we have, there are some public records requests, responses to public records in the supplemental appendix from a couple of different counties. And so we have information, I believe, from Essex and Middlesex as to the number of persons who are incarcerated on orders of this kind over a period of about 7 years. And the numbers are relatively small, but not, you know, not insignificant. And so, but
In comparison, the number of DOR lawyers who show up to do these cases are how many?
the actual number of people on staff?
Well, I'm trying to compare, you know, when we look at CPCS in the Commonwealth in criminal cases, we can look at both sides. Do we know how many lawyers at DOR come and do these cases?
I can certainly find that information out. I don't know it off the top of my head. But again, the number of hearings at which this would be required will depend, you know, substantially on whether the right, should this court find one, is limited to cases in which DOR appears, or if it's simply all cases in which incarceration, and also what is the trigger, whether incarceration is guaranteed or just on the table or whatever it is. So those will obviously affect the number of instances.
Well, it can't be guaranteed, otherwise the judge will have had to make a decision before the judge appoints counsel, so it would have to be reasonably contemplated.
Right.
And what meaning do we take from the fact that Middlesex, which is the most populous county, has many, many fewer than Essex, which is a far less populous county, and that about 75, between 2/3 and 75% of those individuals are not paying the amount due, but in fact completing their civil contempt term?
You know, honestly, I don't know what to take from that other than simply the fact of the numbers. We obviously don't know anything about what happened in those hearings. We don't know anything about the relative means of the individuals who chose to pay versus who did not pay. There is obviously the numbers are. I don't know what to make of the difference between the numbers from Middlesex and from Essex, to be honest.
Okay, thank you.
Thank you.